Before we begin, a quick and important disclaimer. The following content is for educational and entertainment purposes only and does not constitute professional legal, financial, or personal advice. The historical legal systems and social structures discussed are complex and varied by jurisdiction. Therefore, this information should not be used as a substitute for modern legal counsel. Viewers are strongly encouraged to conduct their own due diligence and consult with qualified professionals regarding any current legal matters. Imagine standing before the highest governing body of your state, not to argue for a new law or to protest a tax, but to beg for your freedom from a woman you once swore to love until death. The year is 1810, and you are a merchant in the booming urban center of Philadelphia. In this era, there is no such thing as a quick filing at a local county courthouse. There is no no-fault clause. There is only the public, humiliating, and incredibly expensive spectacle of a legislative petition. To get a divorce in the early United States, you often had to convince the state legislature that your private domestic failure was a matter of public concern. If you failed, you remained legally bound to a person who may have deserted you, defrauded you, or worse, but you were still responsible for her debts and her maintenance until the day you died. This was the reality for men in the early urban centers of the young American Republic, a world where the legal and social stakes of marriage were so high that a single mistake in the selection of a spouse could lead to a lifetime of financial ruin and social ostracization. In this deep dive masterclass, we are going to strip away the myths of the colonial and early national periods to reveal the brutal mechanics of how men navigated the end of a marriage. This is part one of a 10-part series where we analyze the historical trends and case studies that shaped the American domestic legal landscape. By understanding these potential outcomes from our past, you will gain a profound perspective on why the modern system functions the way it does today. For the modern U.S. audience, this solves the problem of historical blindness. It allows you to see the foundational shifts in the American legal system and understand that the good old days were often a labyrinth of legislative gatekeeping and social entrapment. We are going to look at the specific legal definitions, the massive costs involved, and the unique pressures of the city that force men to choose between their reputation and their freedom. To understand divorce for men in early urban centers like Boston, New York, or Charleston, we must first understand the concept of legislative divorce. In the late 18th and early 19th centuries, many states did not have a standardized judicial process for ending a marriage. Instead, marriage was seen as a foundational pillar of the state's stability. Therefore, only the state legislature had the power to break that bond. For a man living in an urban center, this meant that his private life was suddenly thrust into the political arena. He had to hire a lawyer to draft a petition, gather witnesses to testify to his wife's infidelity or desertion, and then hope that a committee of politicians would find his case worthy of a private bill. These case studies reveal a system that was deeply skewed toward the wealthy and the politically connected. If you were a simple tradesman or a dock worker, the sheer cost of lobbying the legislature made a legal divorce virtually impossible. The legal framework of this era was built upon English common law, specifically the doctrine of coverture. Under coverture, a husband and wife were considered one legal person, and that person was the husband. While this gave men significant power over property, it also created a massive legal liability. If a wife ran up debts at a local urban market or took out a loan, the husband was legally responsible for those debts. In the crowded, anonymous streets of a growing city like New York, this became a primary driver for men seeking a legal separation. They weren't just looking for emotional closure. They were looking for a notice of non-responsibility. You would often see ads in early American newspapers where a man would publicly declare that his wife had left his bed and board, and that he would no longer be responsible for any debts she incurred. This was the precursor to the formal legal process, a desperate attempt to protect one's financial standing in an environment where credit and reputation were everything. There were two primary types of legal separation during this period, often referred to by their Latin names to emphasize their gravity. The first was divorcium mensa, which translates to divorce from bed and board. This was not a total dissolution of the marriage. It was a legal recognition that the couple could live apart, but neither party was allowed to remarry. For a man in an urban center, this was a half measure that offered little relief. He was often still required to provide alimony or maintenance to his wife, even if they lived in separate boarding houses. The second, far more coveted and rare, was divorcium vinculo matrimoniae, or divorce from the bonds of matrimony. This was a total dissolution that allowed for remarriage. However, the grounds for this were incredibly narrow. usually limited to cases of bigamy, impotence, or extreme adultery. In early urban centers, the pressure of the city changed the dynamics of these cases. Unlike in small rural villages where a man's neighbors could attest to his character and the behavior of his wife, the city was a place of transient populations and fading reputations. This led to the rise of what historians call the poor man's divorce, which was simply desertion. A man would simply walk away from his life in Boston and reappear in Philadelphia or further west under a new name. However, for the man who stayed, the man who had a business, a home, and a reputation to protect, the legal route was a gauntlet. Consider the case studies of the early 1800s where men had to prove cruelty to the legislature. In a patriarchal society, the bar for a man proving cruelty was exceptionally high. He had to demonstrate that his wife's behavior was so egregious that it made the performance of his duties as a master of the house impossible. This often meant detailed, public testimony about domestic disputes that would be considered scandalous by the standards of the day. The urban environment exacerbated this because news traveled fast through coffee houses and social clubs. A man's creditworthiness, his ability to do business in the city, was tied to his domestic stability. If his marriage was failing publicly, his business partners might see him as a man who could not manage his own household, and therefore could not be trusted with a commercial partnership. Furthermore, we must look at the financial step-by-step process of a legislative petition. First, a man had to publish a notice in the local newspapers for several weeks, declaring his intent to petition the legislature. This gave the wife an opportunity to file a counter-petition. In many urban centers, wives became surprisingly adept at using the legal system to fight back, often accusing the husband of extreme cruelty or failure to provide to secure a better alimony settlement. Second, the man had to provide depositions, which were written testimonies from witnesses taken under oath. This required paying for clerks and specialized legal counsel. Third, once the petition reached the state capitol, it had to be read on the floor and referred to a committee. The committee would then review the evidence and decide whether to draft a bill. If the bill passed both houses, it finally went to the governor for a signature. This process could take years and cost hundreds of dollars at a time when a skilled laborer might only earn $1 a day. The urban pressure cooker also introduced the complication of boarding houses. In cities, men who were separated from their wives often lived in these communal environments. This led to further legal complications regarding adultery. If a man was seen in the company of another woman in a boarding house, his wife could use that as leverage in her counterpetition to deny him a total divorce. The legal system was designed to favor the preservation of the marriage at all costs, because the state did not want the burden of supporting abandoned women and children. Therefore, the burden of proof was always on the person seeking to break the bond. As we move deeper into this masterclass, it becomes clear that for men in early U.S. urban centers, divorce was not an escape, it was a transaction. It was a high-stakes trade-off where a man surrendered his privacy, his secrets, and a significant portion of his wealth just for the legal right to exist as a single individual again. The historical trends show that the legal system viewed marriage not as a contract of happiness, but as a contract of social order. If you broke that order, the city and the state made you pay for it in every way imaginable. In the next part of this series, we will examine the specific roles of proctors and early lawyers in these urban centers, and how they began to turn the chaos of legislative petitions into a standardized and even more expensive judicial system. To navigate the labyrinth of early American divorce, a man first had to find his guide through the fog, the proctor. In the transition from colonial religious oversight to the secular urban courts of the 19th century, the proctor was a specialized legal practitioner who understood the arcane rules of civil and canon law. Imagine if you are a successful master carpenter named Elias in the year 1825, living in the bustling port of Boston. Your business is thriving, but your domestic life has become a theater of psychological warfare. You cannot simply walk into a courthouse and fill out a form. You have to seek out a proctor of the Supreme Judicial Court. This man does not work for a flat fee. He operates on a system of billable actions that would make a modern 2026 corporate attorney blush. Every consultation, every drafted page of the libel, which was the formal document starting the suit, and every subpoena for a witness carried a specific, heavy cost. The proctor's primary job was to transform your messy, emotional human experience into a series of rigid legal proofs. In the early urban centers, the courts did not care if you were unhappy. They only cared if a specific legal injury had occurred. This shift from legislative petitions to judicial proceedings meant that divorce was becoming standardized, but it was also becoming a massive industry. For Elias, the first step was the filing of the libel of divorce. This was a public document that named his wife and listed the specific grievances. The moment this was filed, the clock started on a financial drain that often led men to settle for unfavorable terms just to end the bleeding. The potential outcomes of these cases were heavily influenced by the proctor's ability to dig up dirt. In a city like Boston or New York, this often meant hiring unofficial agents to haunt the docks and boarding houses, looking for anyone who could testify to his wife's misconduct. This brings us to the specific financial mechanics of the urban legal system. In the 1820s and 30s, the cost of a contested divorce could easily exceed $300. To put that in perspective, a well-paid clerk might only see that much money in a year. You had to pay for the service of process, where a sheriff's deputy would physically track down your spouse. You had to pay for the transcriptions of the court clerk. Most importantly, you had to pay the witness fees. In early urban trials, witnesses were often paid for their time and travel. If your case required 5 or 6 witnesses to stay in a city hotel for a 3-day hearing, you were on the hook for their lodging and their lost wages. Historical trends show that many men in the middle class found themselves taking out high-interest loans from private lenders just to keep their legal cases alive. The court was a machine that ran on the capital of the disgruntled husband. Let us look at a case study from the archives of Philadelphia. A merchant we will call Mr. Thompson found himself in a legal deadlock in 1832. He accused his wife of intemperance, habitual drunkenness, which was a rising cause for separation in the increasingly alcohol-saturated urban environment. However, the legal standard for intemperance was not just being drunk. It was being so intoxicated that it caused the destruction of the household economy. Thompson had to prove that his wife's drinking led to the waste of his professional assets. This required him to bring in the local grocer to testify about the volume of spirits sold to the household, the neighbors to testify about the noise of the quarrels, and even the domestic servants to testify about the state of the home. Each of these people had a price for their presence in court. Step by step, the proctor would build a ledger of evidence, but every line on that ledger was a debit from Thompson's bank account. The social control exerted by the city during these proceedings was absolute. Unlike the rural frontier, man might have some anonymity. The early American city was a collection of tightly knit professional networks. When a man like Thompson went to court, his reputation was literally on trial alongside his marriage. If he could not prove his wife's fault, the court might find him to be the aggressor. In the eyes of the 19th century public, a man who failed to control his wife was often seen as a man who could not control his business. Banks in New York and Philadelphia were known to tighten credit for men who were embroiled in messy divorce proceedings. They feared that a large alimony settlement or the legal fees would lead to an eventual bankruptcy. Therefore, the man in the city was fighting a two-front war, one in the courtroom for his freedom, and one in the counting house for his professional survival. Imagine the physical space of the courtroom itself. This was not the sterile, quiet environment we see in 2026. These were crowded, noisy rooms where the public gallery was often filled with onlookers who treated divorce trials as a form of bloodsport entertainment. The newspapers of the day would print the most salacious details of the testimony. For a man of standing, this was the ultimate price. He had to stand there while his proctor cross-examined his wife's mother or her friends about the most intimate details of their domestic life. The goal was to prove extreme cruelty, which for a man, often required showing that his wife's behavior was so erratic and violent that he feared for his life or his sanity. Because the gender norms of the time viewed men as naturally superior and physically stronger, a man claiming cruelty had to provide overwhelming evidence. He had to show that he was not the provocateur, but the victim. The legal labyrinth also involved the answer and the cross-libel. In many case studies, we see that once a husband filed for divorce, the wife would immediately file a countersuit. She would claim that his accusations were merely a cover for his own infidelity or his failure to provide. This created a legal stalemate. In urban centers, the courts were increasingly hesitant to grant a divorce if both parties were found to be at fault, a doctrine known as recrimination. If Elias and his wife were both found to have committed matrimonial offenses, the court would simply leave them married. They would be legally bound, yet socially estranged, a state of purgatory that often led to even more desperate financial and personal measures. The city offered no mercy for the man who could not prove his hands were entirely clean. As the population of cities like Baltimore and Charleston swelled, The sheer volume of these cases forced a change in the way evidence was gathered. We begin to see the emergence of the commissioner. This was a legal official appointed by the court to take testimony in private, away from the prying eyes of the public gallery. While this offered a modicum of privacy, it added yet another layer of fees. The man had to pay for the commissioner's time, the room where the testimony was taken, and the specialized couriers who delivered the sealed depositions to the judge. The professionalization of divorce was turning the end of a marriage into a multi-year project. For the urban man, the standardized judicial system was becoming a gilded cage. He was no longer begging a legislature for a favor. He was now a permanent customer of a legal industry that had a vested interest in the complexity and length of his case. But what happened when the evidence was contradictory? What happened when the city's gossip mill became the primary source of truth, in the absence of hard facts? In the next part of this masterclass, we are going to dive into the shadow world of the 19th century private inquiry agent, the predecessor to the private investigator, and how men in the city began to use professional surveillance to secure the evidence they needed to break their bonds once and for all. We will look at the specific tactics used on the streets of Old New York to trap a spouse in a compromising position, and how this data was weaponized in the Court of Chancery. The stakes were about to get much, much higher. The year is 1844, and the city of New York is no longer a small port town. It is a sprawling, anonymous labyrinth of nearly 400,000 souls. For a man like Silas, a successful importer of dry goods, this anonymity is a double-edged sword. It allows his wife to disappear into the crowds of Broadway or the shadowed alcoves of the newly popular department stores, but it also provides Silas with a weapon that did not exist in the rural villages of his father's generation: the professional shadow. In this era, before the formalized private detective agencies of the mid to late 19th century, men in urban centers began to employ special inquiry agents. These were often former constables or enterprising men who understood that information was the most valuable commodity in the Court of Chancery. Silas is not just looking for an emotional truth, he is looking for a legal kill shot. He knows that in the eyes of the chancellor, the high-ranking judge who presided over equity courts, suspicion is worthless. Only documented, corroborated evidence of a matrimonial offense can sever the bond. The tactics used on the cobblestone streets of Old New York were as gritty as the environment itself. Imagine if you are Silas. You have noticed your wife, let's call her Martha, making frequent and unexplained trips to the Battery or the crowded markets of the 5 Points. You don't follow her yourself. That would be beneath your station and would likely tip her off. Instead, you hire an agent who operates out of a back office near City Hall. This agent's first step is the bribery of the domestic staff. In the 1840s, the servants' quarters were the information hubs of the urban elite. For a few silver coins, a maid would provide a log of who visited the house while the master was at the counting house. This data was then cross-referenced with the agent's own surveillance. This wasn't the high-tech GPS tracking of 2026. This was a man standing in a cold alleyway for 14 hours, recording every person who entered or exited a specific boarding house. The goal of this surveillance was to establish what the legal system called opportunity and inclination. This is a critical historical trend that modern viewers must understand. To win a divorce case in a 19th century urban court on the grounds of adultery, a man like Silas did not necessarily have to produce a witness who saw the physical act. He had to prove two things. First, that the parties had the inclination, meaning they showed a suspicious level of intimacy or affection in public, and second, that they had the opportunity, such as being seen entering a private room or a house of ill repute together. The data weaponized in the Court of Chancery was a meticulous timeline of these two factors. The agent would produce a written report, often dozens of pages long, detailing every time Martha leaned too closely to a specific man in a carriage or every time they entered an oyster cellar known for its private booths. The stakes of this data collection were astronomical. If Silas's agent succeeded in documenting a clear pattern of opportunity and inclination, Silas could move for a total divorce, a divorcium a vinculo matrimoniae. This would not only free him from the marriage but crucially, it would often strip Martha of her right to dower, the legal claim she had to 1/3 of his estate upon his death. In the booming economy of 1840s New York, where land values were skyrocketing, this was a massive financial consideration. However, if the surveillance failed, or if Martha's legal counsel could prove that Silas had hired the agent to entrap her, a tactic known as procurement, Silas could be found guilty of collusion. The chancellor would then dismiss the case, and Silas would be left not only married, but also potentially liable for Martha's increased legal fees and a court-ordered increase in her separate maintenance. Consider the step-by-step process of how this surveillance data was actually presented in court. It wasn't just read aloud. It was subjected to the scrutiny of the commissioner we discussed in the previous part. The agent would be called to testify, and he would have to produce his original notes. In many case studies, we see the defense lawyers for the wife attempting to discredit these agents as vile mercenaries, whose testimony was bought and paid for. This led to a sophisticated arms race of evidence. To counter the mercenary label, men like Silas would often hire two separate agents who did not know each other, so their reports could independently verify the same events. This doubled the cost, often pushing the legal bill for the investigation phase alone into the hundreds of dollars. For the urban merchant, the price of freedom was being measured in the wages of shadows. The urban landscape of cities like Philadelphia and Baltimore provided specific environments that were perfect for this kind of weaponized data. The disorderly house was a common legal term used in these trials. These were not always brothels. They were often legitimate boarding houses or taverns where the proprietors were willing to turn a blind eye to clandestine meetings for a fee. The inquiry agent would often bribe the proprietor of such a house to provide a keyhole witness, someone who would testify to seeing the parties in a compromising state through a door. This led to some of the most salacious and detailed court records in American history. These documents, preserved in state archives, show a level of domestic espionage that rivals the digital footprints of 2026. The difference was that in the 1840s, the footprint was a literal muddy boot print on a staircase or a discarded ribbon in a rented room. As these case studies demonstrate, the transition to judicial divorce in urban centers didn't make the process easier. It made it more technical. A man couldn't just tell his story. He had to prove it with a precision that required professional help. This created a new class of urban experts, the proctor, the commissioner, and now the inquiry agent, all feeding off the dissolution of the American family. Silas, our dry goods importer, is now deep in the process. He has the reports, he has the keyhole witnesses, and he has the inclination documented. But he is about to hit a wall he didn't expect: the doctrine of condonation. In the early U.S. legal system, if Martha can prove that Silas stayed in the same house with her, or even spoke to her civilly after he suspected her of an offense, the court might rule that he has forgiven the act, rendering all his expensive evidence legally void. This brings us to a terrifying realization for the men of this era. Even with a mountain of evidence, the law was designed to keep the marriage together if there was even a hint of reconciliation. Silas has to navigate a world where he must live under the same roof as a woman he is actively spying on, without ever showing a sign of affection or even common courtesy that could be interpreted as condonation. The psychological pressure of this was immense. It turned the home into a tactical battlefield where every word spoken at the dinner table was a potential legal trap. If he was too kind, he lost his case. If he was too cruel, he gave her grounds for a countersuit. But what if the man was the one being watched? What if the very tools Silas used to trap his wife were being turned against him by a spouse who was more legally savvy than he ever imagined? In the next part of this masterclass, we are going to look at the rise of the urban countersuit. We will explore how women in cities like Charleston and New Orleans began to use the doctrine of recrimination to block men from getting divorces, effectively holding their husbands' fortunes hostage in exchange for massive settlements. The hunter was about to become the hunted, and the legal battle was about to move from the shadows of the alleyway into the bright, cold light of the counting house. We are moving from the proof of the crime to the battle over the spoils. The transition from the shadow-filled alleys of investigation to the cold, analytical environment of the counting house marked a turning point in the mid-19th century urban divorce. By the 1850s, the legal landscape in cities like New Orleans and Charleston had evolved into a sophisticated battlefield of financial attrition. Imagine if you are Julian, a prominent cotton factor in New Orleans in the year 1852. You have spent months and a small fortune on inquiry agents to document your wife's indiscretions. You enter the courtroom with a sense of impending victory, only to be blindsided by a legal maneuver that was becoming a hallmark of urban divorce: the doctrine of recrimination. In the early American legal tradition, divorce was seen as a remedy for an innocent party against a guilty one. If your wife, Clara, could prove that you were also guilty of a matrimonial offense, even a single isolated incident of documented impropriety, the court would invoke recrimination. The potential outcome was devastating. The judge would rule that since both parties were at fault, neither was entitled to relief. You would remain legally shackled to a woman you loathed, while your reputation was dragged through the mud of public testimony. This was the birth of the urban countersuit, a tactical nuclear option for the 19th century wife. Clara wouldn't just defend herself. She would strike at the very foundation of Julian's power, his capital. In the civil law-influenced atmosphere of New Orleans, the stakes were even higher due to the concept of the community of acquits and gains. While much of the United States followed common law, New Orleans retained vestiges of the Napoleonic Code, which viewed the assets acquired during a marriage as a shared pool. For a man like Julian, whose wealth was tied up in complex shipping contracts and warehouse leases, a divorce suit wasn't just a personal matter. It was a forensic audit of his entire professional life. Clara's lawyers would file a cross petition, accusing Julian of everything from habitual gambling in the French Quarter to the dissipation of community assets. Step by step, the countersuit functioned as a mechanism of financial hostage-taking. The first and most immediate weapon was alimony pendant light, or alimony pending the suit. Unlike final alimony, which was decided at the end of a trial, alimony pendant light was granted almost immediately. The court's logic was simple. Since the husband controlled the purse strings, the wife needed immediate funds to live and, more importantly, to pay for her own high-priced proctors to fight him. In a city like New York or New Orleans, where the cost of living in a respectable boarding house was significant, these interim payments could be astronomical. Julian was now in the absurd position of being legally forced to finance the very legal team that was attempting to ruin him. This historical trend shows that the more successful a man was, the more he was penalized by the duration of the trial. Every delay, every procedural motion, and every postponed hearing meant another month of paying for 2 sets of lawyers and 2 separate households. The battle then moved into the counting house, the nerve center of the urban merchant's world. In 1852, credit was not based on an anonymous score but on character. A man's domestic stability was a primary metric for his creditworthiness. When news of Julian's messy countersuit hit the exchange, his business partners began to sweat. They saw a man whose assets were being frozen by court orders, and whose focus was divided by scandalous litigation. Case studies from this era reveal that banks would often call in loans or refuse to extend lines of credit to men embroiled in divorce suits involving recrimination. They feared that if the court found both parties at fault, the resulting legal limbo would lead to a private settlement that would drain the man's liquidity. The countersuit was a way to force a man to the bargaining table by threatening to collapse his professional world. Imagine the pressure on Julian as he sits in his office near the docks. He has the evidence to prove his wife's fault, but she has enough evidence of his business dinners in the city's more colorful districts to trigger recrimination. He is caught in a legal stalemate. If he proceeds to trial, he might lose his business due to the credit freeze and the endless alimony pendant light. If he withdraws, he remains married to a woman who now has a documented map of his vulnerabilities. This led to the rise of the shadow settlement. This was an off-the-books agreement where the husband would pay a massive lump sum to the wife in exchange for her withdrawing her cross-petition and allowing him to proceed with an uncontested suit on the grounds of desertion, a much less scandalous charge. These settlements were often coordinated by the proctors behind closed doors, turning the court into a theater where the ending had already been bought and paid for. The complexity of these cases in urban centers also introduced the inventory and appraisement. In New Orleans, the court would appoint a public official to create a line-by-line list of every piece of property, every slave, every share of stock, and every piece of furniture the couple owned. For a man in 2026, this might seem like a standard part of a divorce, but in the 1850s, this was a massive violation of patriarchal privacy. It exposed the man's true net worth not just to the court, but to his competitors. If Julian was over-leveraged or had debts he hadn't disclosed to his partners, the inventory and appraisement would bring them to light. The countersuit wasn't just about winning a divorce, it was about the total leverage of information. We must also consider the role of the city's social hierarchy. In a place like Charleston, the elite families were all interconnected. A countersuit didn't just involve the husband and wife. It involved their entire extended families, who were often business partners as well. If Julian's father-in-law was his primary investor, the divorce was a financial suicide mission. The historical data suggests that men in the highest tiers of urban society were actually the least likely to complete a legal divorce. They were the masters of the legal separation by contract, a private document that mimicked the effects of a divorce without the public scandal of a trial. However, these contracts were often legally fragile and could be challenged at any time. leaving the man in a state of perpetual financial insecurity. As the 1850s progressed, the urban man found himself in a paradoxical position. He lived in a society that legally favored him, yet the urban legal machine had created a set of tools that could be weaponized to strip him of his most precious asset, his professional standing. The battle over the spoils was no longer about who was right or wrong in the eyes of God. It was about who could survive the longest in a war of financial attrition. The countersuit turned the divorce process into a high-stakes game of poker, where the cards were depositions, and the chips were the merchant's very livelihood. But there was one area where no amount of money and no clever countersuit could provide a clear path forward: the children. While the 18th century had seen children as the property of the father, a new radical legal doctrine was beginning to take hold in the urban courts of the mid-19th century. In the next part of this masterclass, we are going to explore the tender years doctrine, the massive shift that began to strip men of their traditional custody rights. We will look at how the cult of domesticity in cities changed the way judges viewed the best interests of the child, and how a man who won his financial freedom might find himself a total stranger to his own heirs. The battle for the money was over, but the battle for the next generation was just beginning. The shift from property rights to emotional custody was not a gradual slope. It was a legal earthquake that leveled the traditional foundations of the American patriarchy. To understand this, we have to look back at the centuries of English common law that preceded the urban explosion of the 1850s. Historically, children were viewed in a manner that seems cold and transactional to a modern observer in 2026. They were considered the legal property of the father, much like his land, his cattle, or his tools. This was based on the principle that because the father was the sole provider and the legal head of the household, he was the only one with the resources and the social standing to ensure the child's future. If a marriage ended in the early 1800s, the potential outcomes for a man were almost always a total victory regarding custody. The mother had no legal standing to claim the children because, under the doctrine of coverture, she effectively had no legal existence independent of her husband. However, as the 19th century American city grew, a new social ideology began to saturate the courtrooms of New York, Philadelphia, and Boston: the cult of domesticity. This ideology divided the world into two spheres. The public sphere, the world of commerce, politics, and the gritty, often corrupt reality of the city, was the domain of the man. The private sphere, the sanctuary of the home, the nursery, and the moral upbringing of the next generation, was the sacred domain of the woman. For a man like Arthur, a successful architect in 1855 Philadelphia, this shift was about to become a legal trap. Imagine if you are Arthur. You have built the very buildings that define the city skyline. You are a man of impeccable public character. But when your marriage dissolves, that very success in the public sphere is used against you. Your proctor warns you that the judges are no longer looking at who owns the child, but at who is best suited to nurture the child's soul. This was the dawn of the tender years doctrine. The tender years doctrine was a judicial presumption that during a child's delicate early years, usually up to the age of 7 or 8, the mother was the naturally superior caregiver. In the urban centers where life was fast-paced and fatherhood was increasingly defined by long hours at the office or the factory, judges began to rule that a father's presence was inherently disruptive to a young child's development. Case studies from the Pennsylvania Supreme Court during this era show a radical departure from precedent. Men who had proven their wives' infidelity, historically an automatic disqualifier for custody, found themselves losing their children anyway. The court's logic was that while a woman might be a failed wife, her maternal instinct was a biological absolute that surpassed the father's legal right of property. Step by step, the legal process for a man seeking custody in an urban center became an uphill battle against sentimentalism. First, the father had to prove that the mother was not just guilty of a matrimonial offense, but that she was morally unfit to a degree that endangered the child. This was an incredibly high bar. In the 1850s, a mother's unfitness usually required evidence of extreme public drunkenness, habitual criminal activity, or a complete abandonment of the home. Simple adultery, which was enough to secure a divorce for the man, was often ignored in the custody phase of the trial. Second, the father had to provide a plan for who would actually raise the children. Since Arthur was a busy professional, he would likely suggest his mother, a sister, or a hired governess. The court would then compare this surrogate care to the natural care of the mother, and almost always favor the latter. This led to a devastating financial and emotional paradox for the urban man. Under the historical trends of the mid-19th century, a man like Arthur would be stripped of the daily presence of his children, but remained legally and financially responsible for their entire upbringing. This was the birth of child support in its recognizable modern form. The court would order a maintenance payment that covered the children's housing, clothing, and education, often paid directly to the woman who had, in Arthur's eyes, betrayed the marriage. If Arthur refused to pay, the urban legal machine had new teeth. He could face attachment of his wages, a precursor to modern garnishment, or even imprisonment in a debtor's jail, which would effectively end his career as an architect. Furthermore, the urban environment introduced a new variable: the professionalized witness in custody battles. Doctors and early psychologists, then known as alienists, began to appear in court to testify about the nervous temperament of children. They would argue that the coarse nature of a father's lifestyle, his smoking, his drinking, his talk of business, was a psychological toxin to a young child. For Arthur, this meant that his very identity as a successful urban man was being weaponized to prove he was a danger to his heirs. He was expected to be the provider, yet the act of providing made him absent and unfit in the eyes of the new maternal preference. Imagine the psychological warfare of the Sunday visit. Before the 1850s, visitation was not a standard legal concept. You either had the children or you didn't. But as the tender years doctrine took hold, judges began to grant access to fathers. However, these visits were often highly regulated and took place under the watchful, hostile eye of the mother's family. For a man who was used to being the undisputed master of his household, this was a profound humiliation. He was a guest in a life he was still paying for. Historical data suggests that many men in this period eventually stopped visiting altogether, unable to bear the emotional toll of their diminished status. This created a cycle where the father's abandonment was then used as further evidence in court to increase the mother's maintenance payments and decrease the father's rights. The impact of urbanization on these rulings cannot be overstated. In a rural setting, a father worked the land alongside his children. The spheres were blurred. In the city, the separation was total. The father left at dawn and returned at dusk. To the judge, the city father was a stranger to his own nursery. This urban alienation became the primary justification for stripping men of their custodial rights. By 1860, the transition was nearly complete in the major cities of the North. The man had won the right to sue for divorce, and he had won the right to protect his business assets through clever proctors, but he had lost the battle for the next generation. This shift created a desperate new class of men in the urban centers. Men who were legally single, financially burdened, and socially isolated from their families. They were looking for a way out of the rigid, maternal-favoring courts of the East Coast. They began to hear whispers of a different kind of legal landscape, far to the west, where the rules were being rewritten on the fly. In the territories and the new states of the frontier, unhappiness was becoming a legal cause, and property still meant property. But how did these men find their way to these divorce colonies? What were the logistical steps for an urban merchant to vanish from New York and reappear in a place like Indiana or South Dakota, just long enough to secure a lightning divorce? In the next part of this masterclass, we are going to explore the rise of the divorce mill. We will look at the specific travel routes, the residency hotels, and the emergence of the first divorce tourists in American history. The battle was moving from the high-stakes courtrooms of the elite to the dusty, opportunistic offices of the frontier, and the price of freedom was about to drop, if you were willing to travel for it. The whisper of the West began as a low murmur in the gentlemen's clubs of Manhattan and the coffee houses of Philadelphia. For a man like Benedict, a prominent textile wholesaler in 1860, the legal walls of New York had become a fortress he could not breach. He had been trapped in a marriage of mutual loathing for a decade. His assets were being bled dry by separate maintenance payments, and the tender years doctrine had ensured he only saw his sons through the cold glass of a carriage window. But then he heard the name of a place that sounded like a promised land of legal flexibility: Indiana. In the mid-19th century, Indiana became the first true divorce colony of the United States, a jurisdictional anomaly that offered the urban man a way to bypass the rigid, moralistic codes of the East Coast. This was the birth of migratory divorce, a historical trend that would eventually see thousands of men boarding westward trains to trade their residency for their freedom. Imagine if you are Benedict. You cannot get a divorce in New York because you cannot prove your wife committed adultery, and you refuse to humiliate yourself by fabricating evidence that could trigger a recrimination suit. You pack a single trunk and tell your business partners you are heading west to scout new markets in the Ohio River Valley. This was the standard cover story for the 19th century divorce tourist. The journey itself was a step-by-step exercise in legal theater. To qualify for an Indiana divorce, you didn't need to be a lifelong resident. You simply had to reside in the state for 1 year. And by the late 1850s, that requirement was often reduced in practice to a matter of months or even weeks if you found the right county judge. Benedict's destination was not a bustling metropolis, but a quiet county seat where the local economy had quietly pivoted to serve the needs of disgruntled Easterners. The secret weapon of the Indiana legal code was the omnibus clause. While Eastern states had a narrow list of specific grounds for divorce, Indiana's 1852 statute included a final, breathtakingly vague provision. A judge could grant a divorce for any other cause for which the court shall deem it proper and celebrated. This was the ultimate discretionary power. For a man in Benedict's position, any other cause could mean anything from incompatibility of temper to domestic infelicity. It turned the divorce process from a criminal-style trial into a civil negotiation. However, the urban man had to be careful. He had to establish a bona fide residency. This meant Benedict had to do more than just check into a hotel. He had to open a bank account, perhaps rent a small office, and ensure his name appeared on the local tax rolls. He was building a paper trail of a life he had no intention of actually living. This created a specialized microeconomy in towns across Indiana and later Illinois. Local lawyers began to place discreet advertisements in Eastern newspapers, masquerading as general legal services, but signaling their true intent with phrases like specializing in Western residency requirements or confidential domestic litigation. These frontier proctors were the antithesis of the high society attorneys in Boston. They were pragmatic, fast-moving, and expensive. They understood that their clients were men of means who were paying for speed and silence. Benedict would pay a retainer that covered not just the legal fees, but often the lodging fees at a boarding house owned by the lawyer's cousin. These residency hotels were the precursor to the Nevada ranches of the 1900s. They were filled with men from the urban centers of the East, all waiting out their clocks, playing cards, and sharing stories of the legal traps they had escaped. One of the most effective tactics used in these divorce mills was the notification loophole. Under the law, a man had to make a good faith effort to notify his spouse of the impending suit. In the 1860s, this meant publishing a notice in a newspaper. Benedict's lawyer would choose the most obscure, low-circulation weekly in the most remote corner of the county. The notice would be buried in the back pages between livestock prices and patent medicine ads. By the time the required 3 weeks of publication had passed, Benedict's wife in New York would be none the wiser. When she failed to appear in the Indiana courtroom, a courtroom she didn't even know existed, the judge would grant a default judgment. In a single afternoon, Benedict would receive his decree, a piece of paper that declared him a single man and, crucially, often ignored the alimony and custody orders previously issued by Eastern courts. However, the potential outcomes for a man returning from a divorce colony were fraught with new risks. This leads us to a fascinating series of case studies involving the full faith and credit clause of the U.S. Constitution. When Benedict returned to New York with his Indiana decree, he often found that the New York courts refused to recognize it. They argued that because the residency was a fraud and the notification was a sham, the Indiana court had no jurisdiction over a New York marriage. This created the phantom marriage. Benedict was a single man in Indianapolis, but a bigamist if he remarried in Manhattan. He was a free man in the eyes of the West, but a fugitive from support payments in the eyes of the East. The urban legal machine was fighting back against the frontier's jurisdictional poaching. To navigate this, wealthy men began to engage in asset shielding that would baffle a modern 2026 forensic accountant. Before leaving for the West, Benedict would transfer his New York property into trusts, held by brothers or business partners, or he would liquidate his holdings into portable wealth like gold or bearer bonds. He was making himself judgment-proof in his home state. This step-by-step dismantling of his financial life was necessary because he knew that once his wife discovered the Western divorce, she would launch a counterattack in the New York courts to seize his assets for unpaid maintenance. The city was no longer just a place of business. It was a jurisdictional minefield where a man had to watch his step at every corner. The social stigma of the Western divorce also played a massive role in the urban centers. While a man might be legally free, the character requirements of 19th century business still applied. A man who was known to have scammed the system in Indiana might find himself blackballed from the most prestigious boards of directors. This led to the rise of the private decree. Men would get their Western divorces but keep them secret, using them only as a get-out-of-jail-free card if their wives ever tried to push for more money or legal control. It was a shadow law for a shadow life. As the 1860s drew to a close and the Civil War reshaped the American landscape, the era of the Indiana divorce mill began to fade under the pressure of federal legal reforms. But the template had been set. The American man had learned that if the law of the city was too rigid, he could use the vastness of the American continent to find a loophole. He had learned that residency was a fungible concept, and that the price of freedom was often just a train ticket and a willing lawyer in a dusty border town. But a new threat was emerging on the horizon. As the urban centers grew even more dense and the Gilded Age began, the state started to take a much more aggressive interest in the morality of its citizens. The era of the private divorce was ending, and the era of the state as a party was beginning. What happened when the government decided that a man's divorce wasn't just a matter between him and his wife, but a crime against the public good? In the next part of this masterclass, we are going to look at the rise of the anti-divorce leagues and the Comstock laws. We will explore how the Postal Service was weaponized to stop men from seeking legal advice, and how the simple act of looking for a way out could land a man in a federal penitentiary. The gates of the divorce colonies were closing, and the urban man was about to find himself in a whole new kind of lockdown. The year is 1873, and the air in New York City is thick with more than just the soot of the Industrial Revolution. It is heavy with a new aggressive brand of moral surveillance. For a man like Franklin, a middle-tier account manager for a thriving iron works, the world has suddenly become a very small place. Imagine if you are Franklin. You have spent the last 3 years quietly planning your exit from a marriage that has become a hollow shell of resentment. You have heard the stories of the Indiana divorce colonies, and you have even begun a secret correspondence with a legal agent in Indianapolis who specializes in the residency loopholes we discussed in the previous part. You think you are being discreet. You send your letters from a post office across town, and you receive your replies at a rented box under an assumed name. But what you don't realize is that the very act of seeking this information has just become a federal offense. This was the era of the Comstock Act, a piece of legislation that effectively turned the United States Postal Service into a weapon of moral hygiene. Anthony Comstock, the head of the New York Society for the Suppression of Vice, had been granted the power of a special agent of the post office. To understand the historical trends of this period, you have to look at the broad definition of obscenity that Comstock and his allies pushed through Congress. It wasn't just about anatomy or literature. It was about anything that threatened the traditional structure of the American family. In the eyes of the law, a pamphlet explaining how to secure an out-of-state divorce was considered just as obscene and injurious to public morals as a lewd photograph. For the urban man, the simple logistical step of gathering legal data was now a high-stakes gamble. Case studies from the 1870s reveal the brutal efficiency of this surveillance. Franklin's secret correspondence is intercepted not because of its content, but because the address on the envelope, the office of a known divorce mill lawyer, has been flagged by Comstock's agents. The potential outcomes of this interception were catastrophic. Franklin isn't just blocked from getting his divorce, he is arrested for using the mails to promote vice. This was the state as a party in its most intrusive form. In the early 19th century, the state was a passive gatekeeper. By the late 19th century, the state had become an active prosecutor of the marital bond. Judges in urban centers began to adopt a terrifying new doctrine. They argued that in every divorce case, there were actually 3 parties involved: the husband, the wife, and the state of New York. The state's interest was the preservation of social order. If a man like Franklin wanted to end his marriage, he wasn't just breaking a contract with his wife. He was committing an act of sabotage against the foundation of the Republic. This led to the rise of the King's Proctor, or the state's intervener. In several jurisdictions, the court had the power to appoint a separate lawyer whose sole job was to find reasons to deny the divorce. Imagine the step-by-step humiliation of Franklin's trial. Even if his wife Sarah agreed to the divorce, even if they had reached a private settlement on the furniture and the bank accounts, the state's intervener could step in and cross-examine them both. The intervener's goal was to find evidence of collusion. Collusion was the legal term for 2 people agreeing to get a divorce. In the twisted logic of the Gilded Age, if both people wanted the divorce, the court was legally obligated to deny it. The historical data shows that this period saw a massive spike in denied petitions. In urban centers where the anti-divorce leagues were most active, the rate of successful divorces for men actually began to plateau despite the rising demand. These leagues, often funded by the city's wealthiest industrialists, saw divorce as a symptom of a dangerous individualism that threatened the labor pool and the inheritance of property. They pressured legislators to repeal the very residency laws that had made Indiana and Illinois so attractive. By 1879, the gates of the divorce colonies were being padlocked by new, restrictive statutes that required 2 or even 3 years of residency and a public trial in the home state of the defendant. For the urban man, this meant the return of the domestic prison. Franklin, now branded a procurer of vice by the newspapers and facing a federal fine that would wipe out his savings, is forced back into a home where Sarah now holds all the legal cards. The social stigma was weaponized. In the 1870s and 80s, a man who had been caught in a Comstock trap was often fired from his position. Respectable firms in 2026 emphasize personal character, but in 1874, character was a rigid, uncompromising ledger. A man who sought a divorce was seen as a man who could not keep his word, and a man who could not keep his word could not be trusted with the company's books. Furthermore, we must analyze the specific role of the private purity detectives. Comstock's organization wasn't just monitoring the mail. They were infiltrating the very boarding houses and hotels where men lived. They would bribe porters to report on any man who was seen with suspicious literature or who received visitors that hinted at a life outside of his marriage. This created a culture of paranoia in the city. A man's private life was no longer private, it was a matter of public record and state interest. The urban center, once a place of anonymity and freedom, had become a panopticon of moral regulation. Step by step, the process of divorce had been pushed back into the shadows of fabrication. If Franklin couldn't use the mail to find a legal way out, and he couldn't use the Western courts without risking a federal prison sentence, he was left with only one option: the production of a matrimonial offense. Since the law required one party to be an absolute villain and the other an absolute victim, men began to hire professional correspondents. This was a dark, gritty industry that thrived in the hotels of Manhattan. A man would hire a woman to be seen entering a hotel room with him. A witness, usually a detective hired by the husband but pretending to work for the wife, would then discover them. This staged adultery was the only key left for the lock. But even this was fraught with danger. If the state's intervener suspected that the adultery was staged, the man could be charged with perjury and conspiracy. The Gilded Age divorce was a high-wire act where the performer was being pelted with stones by the state, the church, and the press. Franklin is caught between a life of quiet desperation and a life of public ruin. The state had decided that his marriage belonged to them, and they were not going to give it up without a fight that would cost him everything he had built. As we look at this historical trend, we see the beginning of a pressure cooker. The demand for divorce was growing as the city became more secular and individualistic, but the legal supply was being strangled by a moralistic state. This tension could only hold for so long. The collusion era was about to explode into a full-blown crisis of legal ethics that would force the courts to either reform or face a total collapse of the judicial system's credibility. But what happened when the fabrication became the standard? What happened when the judges themselves realized that the entire system was a choreographed lie? In the next part of this masterclass, we are going to look at the era of the staged raid. We will go inside the hotel rooms where the unknown woman waited, and we will see how the legal profession in the 1890s became a factory for manufactured evidence. The battle for freedom was moving from the mailroom to the bedroom, and the morality of the state was about to be outsmarted by the desperation of the urban man. The masks were coming off, but the price of admission was higher than ever. The 1890s in the United States marked the peak of a legal absurdity that turned the American courtroom into a grand theater of the macabre. For a man living in an urban center like New York or Chicago, the law had become an immovable object, and his desperation had become an irresistible force. This friction gave birth to the era of the staged raid. Imagine if you are George, a department head at a burgeoning insurance firm in 1896 Manhattan. You and your wife have lived in separate bedrooms for 5 years. There is no hope for reconciliation, but because you live in a state where adultery is the only legal ground for a total divorce, you are effectively a prisoner of your own household. You cannot use the mail to find a Western loophole because of the Comstock laws, and you cannot afford to leave your career for a year to establish residency in a divorce colony. Your only option is to manufacture a crime. The staged raid was a precision-engineered legal event, a step-by-step performance designed to satisfy the court's hunger for a matrimonial offense, while maintaining a veneer of middle-class respectability. George's first step was a visit to a specialized legal firm that operated in the gray market of the Gilded Age. These were not the prestigious proctors of the previous decades. These were the divorce brokers. For a significant fee, usually ranging from $200 to $500, a massive sum in 1896, the broker would arrange for the entire production. This included the hiring of the correspondent, a woman often referred to in legal documents as the unknown woman. These women were often professional actresses or desperate urban workers who were paid a flat fee, typically $25 to $50, to play a part in a 20-minute drama. The logistics of the raid were as ritualized as a religious ceremony. George would be instructed to check into a specific hotel, often one of the secondary establishments near Madison Square that looked the part of a den of iniquity but was secretly in league with the brokers. He would be told to stay in the room with the unknown woman for a set amount of time, exactly enough to establish what the law called opportunity. However, to protect his own reputation and ensure he wasn't actually committing the act, George would often sit in a chair and read a newspaper while the woman sat on the edge of the bed. They were two strangers waiting for a knock on the door. That knock was the arrival of the raiding party. This group typically consisted of two private detectives hired by the broker and, crucially, a witness who could claim to be a friend of the wife. This was the key to bypassing the laws against collusion. If George's wife, Margaret, were the one to discover him, the court might suspect they had planned it together. But if a neutral detective and a family friend broke down the door, it looked like a genuine discovery. Step by step, the witnesses would enter the room, note George's state of undress. Usually he was required to remove his coat and shoes to imply intimacy, and then immediately leave. The unknown woman would hide her face, ensuring her anonymity and protecting her from future legal repercussions. The potential outcomes of these staged raids were highly dependent on the cleanliness of the performance. If the witness's testimony in court was too perfect, or if they couldn't remember specific details like the color of the wallpaper or the time on the bedside clock, a suspicious judge might dismiss the case for fraud. This led to a historical trend of ritualized perjury. Lawyers would coach their witnesses for weeks, ensuring they used specific legal phrases like "in a compromising position" or "caught in the very act of infidelity." The judges themselves were often complicit in this charade. They knew the raids were staged. They knew the unknown woman was a paid performer. But the urban courts were so overwhelmed with unhappy couples that the judges often chose to ignore the lie as long as the paperwork was in order. It was a silent agreement between the bench and the bar to keep the wheels of the city moving. However, for a man like George, the financial and psychological toll was immense. He was paying for a crime he didn't commit to escape a life he couldn't stand. Case studies from the New York Supreme Court archives show that these staged raids frequently led to a secondary industry blackmail. The unknown woman or the private detectives, knowing that George was a man of standing with a high-paying job, would often threaten to reveal the staging of the raid unless they were paid a silence bonus. George was now trapped in a new kind of prison, one where he was constantly looking over his shoulder, waiting for the person who helped him escape to come back for a second payment. Furthermore, we must analyze the role of the urban hotel as a legal character in this era. Hotels began to keep divorce ledgers, where they would record the names of men who checked in under aliases but paid the raid premium. This premium was a bribe to the hotel staff to ensure the raiding party wouldn't be stopped by security, and that no one would call the actual police. The city was becoming a factory of manufactured sin. For the urban man, every step toward freedom was a step into a moral sewer. He was forced to become a liar, a conspirator, and a bribe payer just to achieve a status that a man in 2026 takes for granted. Imagine the courtroom scene when George finally presents his evidence. Margaret's lawyer, having been tipped off and likely paid by George through a back-channel settlement, puts up a vigorous but ultimately hollow defense. The witnesses tell their rehearsed story. The judge, tired and cynical, sighs and signs the decree. George is free, but at the cost of his integrity. He has spent a year's salary and risked a prison sentence for perjury. He has participated in a system that required him to treat a woman he didn't know as a prop in a legal play. This was the reality of the clean divorce in the late 19th century American city. The historical data suggests that by the late 1890s, nearly 60% of all adultery-based divorces in New York City involved some level of staging or fabrication. The legal system had become so disconnected from the reality of urban life that it forced citizens to become criminals to remain law-abiding. This tension was a primary driver for the eventual reform of divorce laws. But for the men of the Gilded Age, reform was a distant dream. They were living in the age of the lie, where the only way to be a good man in the eyes of the law was to prove you were a bad man in the eyes of the public. But even as George walked out of that courtroom with his decree, he was about to face a new and even more persistent predator, the specialized divorce press. As the number of these cases grew, urban newspapers began to realize that divorce news was a goldmine for circulation. They didn't just report on the trials, they hunted for the details of the settlements. They were the ancestors of the modern paparazzi, and they were about to turn George's private victory into a public scandal that would haunt his career for decades. What happened when the secret divorce became the lead story in the Sunday tabloids? How did men in the city respond when their financial settlements and the details of their staged raids were printed in bold type for their bosses and neighbors to see? In the next part of this masterclass, we are going to look at the rise of the scandal sheets and the alimony drone. We will explore how the press turned divorce into a weapon of social assassination, and how a man's net worth became a target for a new breed of investigative journalist. The raid was over, but the exposure was just beginning. We are moving from the hotel room to the front page. The transition from a quiet, albeit manufactured, courtroom victory to the harsh glare of public scrutiny was the final trap of the Gilded Age legal system. By the year 1900, the urban centers of the United States had birthed a new and voracious creature, the yellow press. For a man like Harrison, a high-level executive for a regional railroad in 1902, the conclusion of his divorce trial was not the end of his ordeal, it was merely the opening of a second front. Imagine if you are Harrison. You have successfully navigated the staged raid, you have paid the unknown woman, and you have secured your decree of dissolution. You arrive at your office near Grand Central, expecting a return to normalcy, only to find a copy of the New York Journal on your desk. There, under a headline that screams of your moral failings, is a detailed account of the very raid you thought was a secret. Your name, your salary, and the address of the hotel are all printed for every clerk, competitor, and creditor to see. This was the era of the scandal sheet, where newspapers like Town Topics and the National Police Gazette realized that the private miseries of the urban elite were the most profitable products they could sell. For the American man in the early 20th century, this exposure was a form of social assassination. The historical trends of this period show a direct correlation between the rise of sensationalist journalism and the increasing complexity of divorce settlements. Journalists would bribe court clerks to gain access to the Bill of Particulars, a document that listed the specific, often salacious details of the alleged matrimonial offenses. Because the law required these details to be recorded to prove fault, the state unintentionally created a database for investigative journalists to exploit. The mechanics of this exposure were brutal and systematic. First, the newspaper would publish the basic facts of the filing. Second, they would send a reporter to interview the domestic staff, the hotel porters, and even the neighbors of the parties involved. In a dense urban environment like Chicago or Philadelphia, anonymity was an illusion that could be shattered by a $20 bill handed to a disgruntled footman. Third, the press would analyze the financial declarations made during the trial. If Harrison had declared a net worth of $500,000 to the court, that figure became a permanent part of his public identity. This data was weaponized by his professional rivals to argue that a man who could not manage his domestic affairs, and who was now losing a significant portion of his liquidity to alimony, was a liability to the board of directors. This brings us to a phenomenon that historians and social critics of the time called the alimony drone. This was a specific class of urban women who, often with the help of aggressive lawyers and the threat of media exposure, secured permanent alimony payments that allowed them to live in luxury without ever remarrying. For a man in 1902, the potential outcomes of a high-profile divorce often included a lifetime of financial indentured servitude. The press played a critical role in this by creating a narrative of the wronged wife. Even if the divorce was a result of mutual agreement and a staged raid, the newspapers would paint the husband as a predator and the wife as a victim who required a massive financial cushion to maintain her station in life. Case studies from the New York archives show men paying up to 40% of their annual income in permanent alimony, a figure that was often bolstered by the threat that if they fought the amount, the wife would go to the papers with even more damaging information. Imagine the psychological pressure on Harrison as he realizes that his every move is being watched by a new breed of urban hunter. These were not the private inquiry agents he hired. These were investigative journalists looking for a follow-up story. If Harrison was seen at a restaurant with a new companion, it was front-page news. If he missed a single alimony payment, it was reported as a scandal of the Rail King. The urban center, which once promised freedom through its vastness, had become a hall of mirrors. This led to a historical trend where men began to incorporate their personal wealth into complex holding companies and trusts, not just to avoid taxes, but to hide their true net worth from the prying eyes of the divorce press. They were trying to become invisible in a world that was increasingly obsessed with transparency. The impact on a man's credit was perhaps the most devastating professional consequence. In 1902, credit was still largely a matter of character and social standing. When Harrison's infidelity was splashed across the morning edition, the banks took notice. They saw a man whose assets were being liquidated to satisfy a judgment debt, and whose reputation was being eroded by a weekly tabloid. Historical data suggests that many executives were forced to resign or were quietly demoted following a scandalous divorce, as the stain on their character was seen as a risk to the company's stock price. The alimony drone was not just a financial drain. She was a permanent mark on a man's professional record. Step by step, the process of divorce had evolved from a legislative petition to a judicial trial, then to a manufactured drama, and finally to a public spectacle. The man in the city was caught in a cycle of attrition. He paid the lawyers, he paid the witnesses, he paid the hotel staff, he paid the wife, and finally he paid the press through his lost reputation. The cost of freedom was no longer just a financial figure, it was the total loss of his private identity. This created a profound sense of resentment among the urban male population, leading to the formation of early men's rights, or alimony reform leagues in the 1910s. These groups argued that the law and the press had conspired to create a system that incentivized the destruction of men's lives for the sake of entertainment and profit. Consider the case study of a New York lawyer who, in 1905, famously referred to the divorce courts as the alimony mills. He noted that the city's legal structure was designed to process men like raw material, stripping them of their assets and their dignity before casting them back into the streets. For a man in 2026, the idea of a newspaper printing your bank balance and your alleged bedroom habits seems like a violation of the highest order, but for the man of the early 20th century, this was the standard price of admission to the single life. As we look at the historical trends, we see that the scandal era was the final push that broke the back of the fault-based divorce system. The sheer absurdity of the staged raids, the blatant perjury, and the predatory nature of the press made it clear that the law was no longer serving the public good. It was serving an industry of fabrication and exposure. Harrison, our railroad executive, eventually finds a way to survive, but he is a shadow of his former self. He lives in a smaller apartment, his credit is restricted, and his name is forever linked to the Great Rail Divorce of 1902. He is free, but he is a prisoner of his own history. But the story doesn't end with Harrison. The echoes of these urban divorce battles are still felt today. The doctrines of alimony, the maternal preference in custody, and the weaponization of information in domestic disputes all have their roots in these gritty, turn-of-the-century courtrooms. What did the American man learn from this century of legal warfare? How did the transition from the city's shadows to the front page change the way we view marriage and the state's role in it? In the final part of this masterclass, we are going to pull back and look at the legacy of the urban divorce. We will summarize the hard-won lessons of 10 decades of domestic combat and analyze how the potential outcomes of the past have become the legal realities of the present. The journey from the Philadelphia legislature to the New York scandal sheets is complete, and the final bill is about to be tallied. We are heading into the endgame. The final bill of the American divorce revolution was not merely a financial statement, but a fundamental rewriting of the social contract between the urban man, his family, and the state. By the second decade of the 20th century, the chaos of the Gilded Age, the staged raids, the predatory yellow press, and the mercenary inquiry agents had forced a systemic collapse of the old fault-based regime. For a man like Julian, a senior partner in a burgeoning architecture firm in 1918 Chicago, the legal landscape looked vastly different from the one his grandfather navigated in Philadelphia a century earlier. The potential outcomes were no longer determined by the whim of a state legislature or the salacious testimony of a hotel porter. Instead, Julian found himself entering the newly established domestic relations courts. This was the era of the professionalized settlement, where the state transitioned from being a moral gatekeeper to a social manager. The historical trends of this period show the rise of the social scientist in the courtroom. Imagine if you are Julian. You are no longer just arguing with your wife, Catherine, over a singular act of adultery. You are being interviewed by a court-appointed probation officer or a social worker. This was a radical departure. In the 19th century, the court cared about what you did. In the early 20th century, The court cared about who you were and how your income could be partitioned to ensure social stability. Step by step, the process became a bureaucratic audit. First, Julian had to submit a verified schedule of his assets and liabilities. This was not the invasive public inventory and appraisement of the 1850s, but a confidential financial disclosure that the court used to calculate a standardized support amount. Second, the court-appointed investigator would visit both Julian's office and the family home to assess the standard of living. The goal was to ensure that Catherine and the children maintained the same station in life they enjoyed during the marriage, regardless of Julian's personal feelings or the reasons for the split. This shift codified the concept of the permanent alimony obligation into a mathematical formula. For the urban man, this meant that his professional success was now a double-edged sword. The more Julian earned, the more the state viewed his income as a public utility for the support of his former household. Historical data from this era reveals that the domestic relations courts were designed to prevent women and children from becoming a burden on the city's growing welfare systems. Therefore, the urban man's salary was effectively taxed by the judicial system. This was the birth of the modern support system that persists in 2026. The state had realized that it was more efficient to garnish a man's wages than to police his bedroom. The battle for custody also reached its final, rigid form during this period. The tender years doctrine, which we analyzed in Part 5, had evolved into the best interests of the child standard. However, in 1918, best interest was almost always synonymous with maternal custody. For Julian, this meant the formalization of the weekend father archetype. The court would issue a decree that granted Catherine primary physical custody, while giving Julian specific, limited hours of visitation. This was a far cry from the common law era where children were a father's property. Now Julian was a visitor in his children's lives, a role that was legally mandated and socially reinforced by the urban school systems and medical professionals who saw the mother as the primary point of contact for the child's development. Consider the case study of the 1915 Alimony Reform League in New York. This group was comprised of thousands of men like Julian, who felt that the legal system had become a machine for financial extraction. They argued that the historical trend of awarding permanent alimony, even in cases where the wife was young and capable of working, was a relic of a bygone era of female helplessness. They pointed to the rising number of women in the urban workforce as evidence that the law was out of step with reality. However, the courts were slow to change. The potential outcomes for men who attempted to reduce their alimony were bleak. The burden of proof was on the man to show a catastrophic change in his financial circumstances. This led to the creation of the alimony jail, a specific wing of urban prisons where men were held for contempt of court if they failed to meet their support obligations. This was the ultimate realization of the state as a party. The government would physically imprison a man to protect the financial interests of his former spouse. Furthermore, we must look at the legacy of the proctors. By the early 20th century, the specialized divorce lawyer had become a permanent fixture of the urban elite. These firms no longer relied on the drama of the staged raid. Instead, they became masters of the pre-trial settlement. They understood that the city's courts wanted efficiency. They would negotiate the terms of the support, the division of the furniture, and the visitation schedule in private offices long before a judge ever saw the case. This professionalization removed the public scandal but significantly increased the legal costs. A man in Julian's position could expect to pay thousands of dollars in fees to ensure that his settlement was ironclad, and that he avoided the humiliation of a public trial. The price of freedom was now a high entry ticket to a professionalized legal industry. As we stand in 2026 and look back at this century of domestic combat, the lessons for the modern U.S. audience are profound. The early American urban centers were the laboratories for every legal mechanism we deal with today. The transition from property rights to emotional custody, from legislative favors to judicial formulas, and from moral policing to financial management was all driven by the unique pressures of the American city. The urban man was the test subject for a system that prioritized social order and financial stability over individual happiness or traditional patriarchal rights. The historical trend suggests that as the city grew, the law became more distant and more mechanical. The men of the 18th century begged for their freedom, the men of the 19th century manufactured it through lies, and the men of the 20th century bought it through standardized settlements. This is the deep dive masterclass in American legal evolution. By understanding these potential outcomes of the past, you can see that the modern system is not an accident of history, but a carefully constructed response to the chaos of the urban frontier. The good old days were never simple. They were a labyrinth of shifting rules where the only constant was the cost of the exit. But as one chapter of American domestic history closes, another is always beginning. The rise of the domestic relations courts in 1918 was just the precursor to the massive social upheavals of the mid-20th century and the eventual arrival of no-fault divorce. What happened when the state finally admitted that a marriage could end simply because two people no longer wanted to be together? How did the urban man's role change when the law finally abandoned the hunt for the matrimonial offense? The journey through the early urban centers has shown us the foundations. The next series will take us into the era of the Great Migration and the suburb, where the rules were rewritten yet again. If you thought the battle for the counting house was intense, wait until we analyze the era of the no-fault explosion and the rise of the joint custody movement. The story of the American man's search for freedom is far from over. It is simply entering a new, even more complex stage of the legal game. Keep watching as we continue this masterclass into the modern age.